Welcome to Sheppard Mullin's Nota Bene, where we tackle current national and international headlines affecting multinationals doing business without borders. I'm your host, Scott Mayberry. Let's get started. Welcome to episode 173 of the Nota Bene podcast. I'm your host, Scott Mayberry. My guests today are Navroze Palekar of Cyient and Anne O'Brien of Sheppard Mullin. We're talking about global business in India today. Before I introduce our guests, I'd like to thank our viewers and listeners in over 100 countries worldwide. We're so glad you're tuning in, and please keep the feedback coming. It definitely influences our programming, and you can email me directly with your comments and suggestions. My email address is in the program description. My guest, Navroze Palekar, is Vice President and Global Head of Legal and Compliance for Cyient. Cyient is an engineering research and development services provider. Their clients include 30% of the top 100 global innovators around the world. And Navroze is an old friend, and it's a pleasure to have him on the podcast. Navroze, welcome to Nota Bene.
Thank you, Scott. Thank you. And thanks everybody at the Sheppard Mullin team for having me. It's an absolute pleasure to be on this podcast.
It's great to have you. Our guest, Anne O'Brien, is familiar to viewers of our podcast. She's the head of the criminal antitrust and cartels team for the international law firm of Sheppard Mullin. She advises clients facing criminal and civil government antitrust investigations and litigation. She also served for 2 decades in the U.S. Department of Justice, both as a prosecutor and as a manager within the DOJ Antitrust Division. And so she's here to share her vast experience and insider insight with respect to the government's enforcement priorities. And with that wealth of insight, there's no better person to help our audience talk about antitrust and trusts. And welcome to Nota Bene.
Thank you.
So we're talking about India, and India is the world's 6th largest economy. Also, it's growing at a steady 6 or 7% every year, and so it's now expected to pass Germany and Japan by 2030, which would make it the world's 3rd largest economy after the United States and China. India maintains a robust import-export trade in both goods and services with the entire globe. The exports of India of goods and services are about even, and India maintains a very favorable climate for foreign investment. Multiple waves of structural reforms recently have steadily improved that climate. And so there's a lot of our listeners who are doing business in India or are planning to do business in India. And so let's start with competition law, or what we'd call trusts. And for that, Anne, I'll turn to you.
Thanks, Scott. So let's start in the trust section of this podcast, talking about labor and non-competes, a hot topic that, Navroze, you know a lot about as the global legal lead navigating Cyient through these issues during recent times, and really times of change in the U.S. and an antitrust enforcement context, where the FTC has tried to impose a non-compete ban, and we've seen a lot of focus on labor as a sector and competition for labor, with no poach and wage fixing cases even being brought criminally in the US. So with that, I've been seeing a lot that there seems to be similar concern and focus in India. I'm reading about this in the press, but tell me from your real on the ground perspective, what are these efforts to focus on labor concerns regarding non-competes? What does that mean for a global organization like yours operating in India, but also with work being done in the US? How do you navigate these challenges?
It's quite interesting, and the topic that you kind of brought to the fore is something that you and I have also worked very closely on, and especially for Cyient and managing that aspect of the law in the United States. But I will leave I will leave those details for your expertise to comment on, while I kind of give you some of the India flavor on this, how we've had similar matters being dealt with out here. So when it comes to the labor non-competes, I think we have not had any specific law that provides for labor non-compete or anti-competition provisions to be applied for employment. However, we have the basic principles of the Contract Act in India, which kind of address that in at the very grassroots level in a employment contract. Um, for example, uh, if there is a clause that prevents an employee from working with a competitor of his or her employer, then the Indian Contract Act has provisions which make that particular clause void and cannot be enforced by the employer against the employee. So it goes against the basic tenets of also trying to restrict the movement of employees from one employer to the other, and it also upholds the constitutional right of employment. There are two aspects that come to play out here. One is, of course, the constitutional right, and second is the contractual right. Now, when it comes to the contractual right, of course, there are several judgments that have been passed by various high courts within the country and upheld by the Supreme Court. Is that such non-competes are not tenable and they cannot be enforced. However, there are exceptions, and like in every country, you will have those exceptions. One is where if the employer is able to show the importance of the employee to the organization, or the amount of information that they are exposed to, or the data that they are exposed to, is of such a nature that gives the company a competitive edge over their competitors, then there is a reasonable cool off period that is permissible under the law. And that reason, the test of reasonableness, is anywhere between a 6 month to a 12-month post employment termination obligations.
Is that like a gardening leave type situation, Navroze?
Absolutely,
Okay.
absolutely. You're absolutely right. So that is like a gardening leave, and uh, the employer is obligated to compensate the employee during such time. However, there are other situations as well, and this is now I'm going, shifting the focus from executives to maybe the engineers or and I'm focusing my attention only to the IT industry because that's where I've spent majority of my career. So, in that, to where you have software engineers who are working on a particular project, if they wish to move on and wish to join a competitor or including a customer on whose project they are working, let's focus on the competition part. The customer generally has to consent on the movement of the employee, and at the same time the employer has to ensure that uh, there is a reasonable clause that is put in such employment agreement, which helps them to work with a competitor of the customer or a competitor of the employer immediately after their termination of their employment agreement. But they will not work on similarly placed projects for the competitor, or they will adhere to the strictest levels of confidentiality to ensure that there is no leakage of confidential information, data, or trade secrets. So those if those safeguards are put in place, I most of the courts have found it easy to kind of rule in favor of enforcing the non-competes based on the test of reasonableness.
And that's very similar to where we are in the US. And we've talked about the FTC's attempt at a non-compete ban in the US that had exceptions, including for M&A work and M&A post-transaction employment and things like that. But I still see a lot of, and I'm looking at it from the antitrust perspective, not the labor and employment perspective, obviously for my clients in the antitrust world, but I still see a lot of non-compete provisions. I have a lot of clients coming to me for antitrust counseling, India and globally and in the US. So there still seems to be a lot of them. Is that your sense too, or navigating this? I mean, I'm not seeing the downtrend I might expect given the status of the law in India, in the US, and elsewhere.
It's quite interesting that you raised that point, and especially since we've gone through some of the landmark uh, you know cases and the landmark decisions that have been made by U.S. courts of late, and we work closely on these matters. And especially for a company like us, which has a global presence, and majority of the countries now are moving towards the direction of banning non-competes completely. And we've seen that trend in Europe as well. And we see that, and with majority of our presence in the countries that have enforced those bans, we have the challenge of dealing with customers on a day-to-day basis who have not read through these updates in the law. There was a very recent case where uh, uh, one of my colleagues was dealing with a customer in the North Americas, and the customers council was not aware that non-competes have been banned, and they uh, continued arguing against it, and they wanted to have it in wanted to enforce the clause in the contract. So at the end of the day, we had to literally pull up we had to do a little bit of research for the customer, pulled up the data, pulled up the regulations, the judgments, sent it to the customer, and that's what convinced them. And in fact, we also received a feedback from the procurement manager of the customer saying that he appreciated that we kind of educated the opposing counsel or the customers counsel on the non-compete provisions in their jurisdiction when we did not we actually come from a different jurisdiction altogether.
That's surprising to me and funny, and it makes me think about the practical effect. Like, what would it be? I'm sure it's in millions or hundreds of millions of contracts around the world. Uh, what's going to happen next, and how would that affect business if everybody had to have that discussion on every contract in the future?
It's all a matter of keeping yourself abreast with all the developments in the law. And as an in-house counsel, I think we apart from just making sure that we keep ourselves updated, we rely a lot on our local partners in the who are our law firm partners who are empaneled with us to provide us with those updates on a regular basis, because that's the only way we would know. I mean, while I would keep a track of what are the updates in the local jurisdiction within India, I would not know what's going on in a Scandinavian country or what's going on in Canada. Those are the updates that I would look for from my local law firm partner. And even I have seen that they do send their updates on a regular basis. I mean, they are very very proactive, and we receive them. We receive them on a weekly basis, but it's the prerogative of the in-house counsel to be responsible and accountable for updating their knowledge and going through that on their own accord rather than waiting for. So it should not be a hot fix approach where something goes wrong and then you start researching on what should have been the approach on that. Rather, you preempt on what should be the next step, not what should be a plan of action, and implement those steps within the organization immediately so that you're in compliance with the requirements.
And I very often get the call from the antitrust context after in-house counsel, like you or others have gone through that process, and you might be dealing with not even a lawyer that's negotiating the contract and a partner in some sense that really, really wants this, so you don't steal their employees. I find that the more they really, really want it, the more concerns we sometimes have because the reasons they really, really want it might be the reasons that trigger a review. So sometimes I will say, antitrust is a scary word or competition laws and some education calls, from outside counsel. I spend time doing that and also just looking through tons of, well, we've been using this contract form for years. well, I see a lot of large companies going through a process now, to Scott's point, where they're doing an overall review and saying, just because we've used this form for years, let's take a fresh look at it and see if it meets these criteria globally for this issue. So I think there's still a lot of development here that we're going to go through, right?
Absolutely. And see, at the end of the day, you have to be proactive in taking those steps. One, to educate yourself, and also to make sure that you change the process internally. So the moment we saw these changes in the laws across the globe, and rather, let me put it this way, in majority of the countries that we are operating in, we we took an executive decision to amend our employment templates and our contracting process, especially in dealing with certain customers, to ensure that we remove the restrictive covenants in toto. And when we get a pushback, and of course on the employment side we never get a pushback, but on the customer side, when we get a pushback, to include the clauses. And in 80% of the time when we are using customer paper to sign up on our contracts, they do have these clauses, and when we strike them out and we send it back, now what we started doing is, we, rather than getting into an argument with them or a negotiation with them on those clauses, we give them the hyperlink to the provisions of the law that say that, you cannot, that non-competes are not, are unenforceable. So that's where the customer is also appreciative of the fact that, we are trying to make sure that we are not striking off something just for the heck of striking it out, but with a absolute rationale behind it.
Yeah, and I think we're going to have a lot more of those conversations. And I'm always happy to be called in to be the antitrust heavy and be the backup on this. So, the second topic I just wanted to cover, and the final topic, talking about trust in this episode, is one I know is near and dear to your heart and business, and really a hot topic in India as well as the US, and that's tech and big tech. So really what we've seen in the US, and this is on the news in the US every day, and I feel like more people know what antitrust is than ever in my career, but blockbuster monopolizations and antitrust suits against big tech companies are playing out in the courts in the US. And I've been really interested following, and he might get tired of me sending you these headlines, but there's been a lot of recent headlines in India, and I've seen really kind of parallel and similar concerns, particularly in the area of AI and tech, from the head of the competition committee of India. Even this week, I saw references, and really, I think that the concerns expressed there are very similar to the core concerns in the US. And it's that somehow tech, which is great, and AI, huge tool we're trying to figure out how to harness for its best uses, can pose challenges to competition. And what we're seeing in the US, and I hear that concern also in headlines, but not yet cases in India. So I want to hear your perspective on that. Is that artificial intelligence, AI, can be used to facilitate collusion, price fixing. We're seeing it play out in rental markets for housing, hotels, where the idea is we have this great algorithm that can help you to suggest pricing that takes a lot of data in, that takes a person a long time to crunch and takes a computer a very short time. So let's use that. Seems like a great idea for price, for supply, but those are also hot button antitrust issues. So, that's the lead up of what I'm seeing in the US. And I really want to hear your views on how do you see those concerns about tech and AI playing out in India, and how are you thinking about them from your business perspective?
Considering that it's so new, and the novelty of this topic is such, where you have all the competitors, or the users of the AI tech on one side, and the AI tech is basically being fed with data by all these competitors, and this data is not exclusive to any one user at any point in time. So the data that is of, say, user one, which of course it's anonymous, but at the same time it will help to determine the pricing for user 4 or user 3. And similarly, the same pricing that is given by the other users that is being fed back into the system, that, the search engine, they keep on adding additional layers of data collecting from the from the end customers. That data is being fed into the backend AI system, which is basically free for all. That is the reason why the four users can then adjust their pricing in such a way where neither of them will go below a certain price point, which in the absence of the AI tech, they would have probably been undercutting the other to make sure that they get, they add to their top line.
Yes, that's the hot topic here, and what we're seeing from an aggressive DOJ and FTC in some briefing is that they would say even anonymized aggregated data, so you don't know whose it is, which I've counseled for years is lower risk. That if that's used to train models, and that can be concerning. So therefore, I question if you're developing that tool. I see a lot of marketing about like how great the tools are, and they are great. But if that marketing is you can use it to keep your prices up, that's red light alarm bells, I think, in the US now. So what you're discussing, I think, is real time everyday stuff. So are you having these? Because I know Cyient is very innovative in terms of both development and usage of tools like this. Or is antitrust in those issues? And I think that'll be my last question here is that part of the discussion when you're developing or using these tools, or are we not there yet, that we have more work to do raising awareness as lawyers, as in-house and outside lawyers?
I would vote for the latter. There is a lot of awareness that needs to be raised, and not just that. I think the in-house counsel need to be prepped with the changes in AI laws, and especially their applicability across. Now, here's the thing, right? We have the European Union coming up with so they've set a benchmark by putting up the EU AI Act in place. Now, it's not too far off where the other countries will follow and set up their own systems and their own legislations, which will kind of, for lack of better term, mimic the EU AI Act. And that is, on one hand, there will be a parity across jurisdictions, but at the same time, the implementation and the awareness amongst the actual users of AI tech, they are the highly skilled software engineers or engineers in the industry. They are not aware of what they are getting into. So it will be the prerogative of the in-house counsel to keep themselves aware of the compliances that they need to put in place in with respect to the contractual requirements that they have with their customers. We've seen certain AI clauses coming up in some of our contracts, and they're quite interesting. But at the same time, uh, it is only, we've seen a very few of them being actually making it through till the execution stage, because what we say is that let's not have this as a standard, but if we are going to be utilizing AI tech for any of your projects, let us put a clause in place under the relevant SOW rather than putting it under the contract as an umbrella document, because we don't know what are the changes or the amendments to the law, and that is the only way we can mitigate that risk at the moment.
I will say, now that I'm going to my 5th year working with Cyient and a lot of the scientist engineers, the great thing about engineers, me as an antitrust lawyer, doing these very boring antitrust compliance, when I get into the AI and tech stuff, is some really smart people, and engineers are smart, so they want to understand what's the concern. So my hope for the future is that the smartest of the smart and the engineers that you and other companies have, they're going to be the ones that think about how to both harness the tools that we have and keep in mind the concerns, because I think there is a lot of good that can come of this. And the antitrust laws, especially in the US with the upcoming new administration, there's a lot of eyes on, but this is not an issue that's going to go away globally. So you're sitting right there in the hot bird seat, as we say, and seeing it every day. So I know you and I will have many more conversations on this, but we'll end this part and I'll turn it over to Scott for the trade portion.
Thank you, guys. That is really great. And for our audience, it's notable that we're getting some kind of cutting edge views on not just on what's happening in technology, but also in that crossover between the technology and the law. And so, big headline for me is there's a lot of work yet to be done in artificial intelligence and the algorithms that are used for some of these pricing models for all kinds of businesses. And the challenge for all of us in the future is to figure out how to make those work, make them work for us and do what we want them to do, and also to keep them from getting us crosswise with the antitrust authorities around the world. So that's to be determined, and I'm sure we'll have some future episodes on that. And stripping gears now just a little bit and moving to the issue of issues of international trade. There are a million things we could talk about with trade with India. The one that's on my mind a lot recently is Russia sanctions. So President Biden has continued to commit to a tough economic sanctions regime against Russia in the wake of the invasion of Ukraine, and UN and EU have also followed suit. These are very important current U.S. national security and foreign policy goals for this administration, and Russia has been one of India's largest trading partners. In particular, there's a lot of trade in Russian crude, among other products. So, Navroze, what do you think the Indian strategy is with respect to Russian trade, and in particular the effect on the sanctions regimes?
It's I think it's about more than 2 years since the war broke out, and ever since the sanctions have been put in place, several industries have been impacted. With those sanctions, of course, we have a lot of Indian industry actually does a lot of business with Russia. Considering we've seen that in the pharmaceutical industry, the petroleum and energy sector, manufacturing industry as well. Now, and several of the if you've seen that American conglomerates, European conglomerates, even Australian conglomerates have had their operations in Russia, which they have either shut down or they have isolated them and spun them off as independent entities to operate independently. In the case of the Indian industry, I think especially I can speak for some of the companies that act as service providers to their customers in Europe or in the Americas. Because of the neutral position that India has taken in this entire dispute between Russia and the rest of the world, if I may put it, there have been questions that have been raised and queries that have been asked by several European and American companies on the nature of business that is being carried out along with a vendor or a customer that may have a link to Russia. So there are two parts. One is doing business directly with Russia, and two is doing business for a customer that is that is based in a country that has sanctions, that has imposed sanctions on Russia. So to address the first one, which is a very easy one, doing business directly with Russia, I think Indian companies are not barred in doing that, as long as there is, as long as the transaction and the currency of trade is in INR, then it's a very straightforward transaction. Secondly, there are also companies that have joint ventures with Russian conglomerates in the manufacturing space, and they are inviting bids and floating RFPs from service providers to provide services within India itself. So which is a good thing for India, because which means that we are getting the entire the economy or the backbone for this industry, for the manufacturing industry, is growing because of the additional business that the Russian companies are providing India, since it is not going anywhere else in the world. So it is all getting localized within India.
Yeah, it's
So
a
that's
very unique position for India to be in, and it's a position that India, I think, as a national strategy, has pursued for decades. Really, a non-alignment type of strategy, if you want to call it that. And my thought about that right now is that one, as a trade controls compliance lawyer, I'm always counseling our clients on how uh, to stay abreast of the U.S. laws and the other applicable laws, and how not to run afoul of them. With the U.S. sanctions in particular, the main tool, as you know, that the United States has is control over the U.S. dollar. And so any transaction in dollars is going to be caught by the US sanctions, and any transaction in euros is going to be caught by the European sanctions. And so my understanding of a lot of what's happening is that a lot of the trade between India and Russia is happening in rupees. And there's a lot of talk now about the rupee accounts that are being held by the largest Russian banks for purposes of this trade. And it's a solid move to make, and it's very interesting to think about what that's going to mean for the Indian economy in the future. I guess not to mention the Russian economy, because there is a question about how useful those massive account and growing accounts are going to be to Russia. Because I think it's quite clear that they're going to be useful to India, but maybe a little less so for Russia. So it's an interesting thought to think about how it's going to play out in the future. What do you think is going to happen next in terms of this trade?
I'll just kind of sum it up in a short sentence, that let's go back to your opening comment of how Indian economy is growing and where we are today and where we will be in 2030. I think that is a testament to the boost that we are getting for the economy out here, with such kind of with uh, let's put it this way: we are taking the advantage of the sanctions that have been that have been imposed on Russia. So, which is great. I mean, it's not harming anyone, as long as there is free trade, uh, as long as it's advantageous to the economy. I think it's good. uh, Second is the point that I come back to in terms of how the uh, what are some of the concerns that the industry is seeing from their American and European clients, is on the linkage to Russia. So, and it's not just a direct linkage. They want to go like 2 or 3 levels down of relationships, of say, for example, is there a director on the board of a customer or of a vendor who is of Russian origin, or or is there a company that holds interest or shareholding with a vendor or another customer which is of Russian origin, etc. So as long as I think you and I have spoken about that, Scott, and I would also like to thank our friend Reed, who has advised us in this matter, quite extensively. He and I had a very long discussion on this, and at the end of the day, we look at it as long as the Indian industry is taking the necessary safeguards to ensure that none of their European, American, associates are involved in a transaction, or even Australian associates for that matter, involved in the transaction that is dealing with a entity that may have a Russian linkage. In that sense, it should be in the clear as long as the transaction is being dealt straight out of India. Second and the most important thing is, as long as it is being, it is transacted in INR or the rupee and not the euro or the dollar.
And the concerns you're talking about are driven specifically by the U.S. laws and the analogous European codes, and it has to do with making sure that everything is independent of the controls that the United States and the Europeans can impose. And again, that really means a lot to India, and it's in some ways the fruit of decades of Indian national policy. So it remains to be seen what's going to happen with Russia sanctions after the change of administration. And I'm sure we'll have to have another session soon on the Trump era international trade issues with India. But for now, I think we've covered all the ground we're going to cover today, and I really appreciate having you both. Anne, Navroze, thank you so much for being on with us today.
Well, thank you so much, Scott and Anne, for having me. It was an absolute pleasure.